this is actually the point that I was going to ask you. Is there some confusion about the rules or the guidelines that either side of the parties used in conducting the primaries that raised two different candidates at the same time? On the one hand, you also said that you've also validated this point when you said that either of the parties is standing on one solid ground or the other, one rule or the other, one guideline or the other. Is there something wrong? Is there some confusion that needs to be ironed out at this point for future references?
It's probably just the fact that the NWC changed the rule. Like NWC made a different pronouncement that is inconsistent with the pronouncement made by its superior, the NEC. Now, both parties used one of those directives, and perhaps we will not be having this conversation if the party that's using direct primaries had used direct primaries where all aspirants would have participated. But what has led to this now is the fact of exclusion of legitimate members of the party who aspired to be part of the process. So if there was direct primary and all aspirants partook before they elected delegates and all that, or before they elected party officials, in this scenario, we wouldn't be having this conversation. So what has conclusively marred their own position is the fact of disobedience of court order. In the circumstance, the question is, which one is valid? The other one does not exist. So in the eyes of the law, only one primary took place on that day, not two.
And now,
that is what the Supreme Court has affirmed.
And now the two have been nullified
by the Federal High Court. And the Court of Appeal is now being asked to revisit the question, the answer given by the Federal High Court. It's important perhaps to also clarify. The Federal High Court did not say the primaries is barred from beginning. It said, I see two reasons why it is difficult for me to grant your prayer. One is that I am convinced that the state high court judgment also affects your primary because it says all primaries. But of course, that clearly is wrong because ruling number 8 of that state high court primary, of that state high court judgment, clearly states that everything that was done in conjunction with and with the participation of those delegates purportedly elected in disobedience of court order. So that judgment was clear and does not leave anyone in doubt. Unfortunately, I think one of the counsel urged the court to hold that view and the court accepted it. So it was wrong. And the record, the certified true copy of the judgment shows that it was wrong. Now on the second score about NWC participation, as I have just explained, it's not a requirement of law. What the law requires is equal opportunity for party members to be able to vote for the aspirants. And the section of the law that mandates, empowers parties to prepare regulations or add things to their constitution talks about parties that want to go by indirect primary. So that provision that governs indirect primary is a superfluous provision that does not apply at all to direct primaries. Direct primaries is governed by subsection 3. And if you look at that subsection 7 that empowers the parties to make provision, it said they should make for indirect. So when you make a provision for what you are not empowered to make, in the eyes of the law, it does not exist. So the court adopted, the Federal High Court adopted a wrong provision in determining validity of what otherwise he agreed was held properly.
What then, in your view, should be the case now? Because the Magnus Abe faction believes that the court has wronged it brutally, and they feel that the court shouldn't have taken that stance against them because they didn't see themselves as breaking any of the rules or any of the guidelines. What then happens to the Magnus Abe faction now?
That's why they are in the Court of Appeal. Now, it's for the Court of Appeal to look at the argument and ask itself whether the state high court judgment applies to all primaries beyond governorship, House of Assembly, National Assembly, which is what that court meant by all primaries. Because again, if you remember, that law, subsection 10 of that law, subsection 11 of that law, does not give the courts power, whether federal high court or state high court, it does not give courts power to stop the conduct of primaries or the conduct of an election that is due. What the court can only do is to invalidate one that has not been done in accordance with the law, with the operative law. And so the Court of Appeal is now to determine whether the Federal High Court was wrong in construing that state High Court judgment as applying to the direct primaries, which was not before it, which was not an issue and did not offend any law. And in determining whether it thinks, considering the provisions of subsection 3 and subsection 7 of the Electoral Act, it has to determine whether, in its opinion, those rules that are required to be made for indirect primaries also applies to direct primaries, because the law was clear. The law made provision for direct primary in subsection 3.
All right.
And in subsection 4, it talks of what should apply to indirect primaries.
Okay, let me ask you then, Prof, because if this matter is supposed to come up on the 25th,
yes,
the other part of it, and the election for the Senate and the House of Reps, of which they're supposed to determine, comes up this weekend.
This Saturday.
What happens?
To the best of my understanding, the matter is reserved for judgment. Counsel are to be notified when judgment will be given. I believe that the court knows what it's dealing with, and I expect that the court, in order to do justice, will ensure that it does what it has to do before the date of the election. If, in any case, the court does not do so and that election comes, the one of Saturday comes, which is just 48 hours from now, what it will mean is that the court has disenfranchised those members who are seeking for placement in the National Assembly. But I want to think that the court knows better and that the court will invite the counsel to both sides before that time. What is adjourned to 25 on that day on the floor of the court is the one filed by Toye Cole. And I can imagine that the court felt comfortable to do so because the Supreme Court has already pronounced that they are not in issue, that they are not parties. Perhaps on that day, the court will have to determine whether that appeal is still competent, considering that the Supreme Court has clarified the situation concerning them. So for the one of Senator Magnus Abe and the products of the direct primaries, the court reserved judgment and said the parties will be notified when judgment is ready. I want to believe that the court will do justice in that case.
Prof, for those who thought that the court initially, when they said that they were going to give, when they gave that stay of proceeding and then accelerated the hearing, they thought that they wanted to avoid any irreparable damage they were going to cause the party in the event that the judgment goes their way and they don't lose out. But now that the judgment is going to come much after the election, so wherein lies that initial intention or the mindset that they wanted to avoid all of that, because they now, aren't they going to be guilty if they give judgment after the elections of themselves engaging in an academic exercise?
Yeah, if they give judgment after the first election, it will mean that they've done irreparable damage to those members of the party. I think there are altogether 43 claimants, or yes, 43 appellants. It will mean that those appellants, I think is it 16 or 18 of them in the House of Reps and 3 on the Senate. It will mean that they have done irreparable damage to those ones. But again, that's why I said I am still hopeful, because what the court did yesterday was to say judgment is reserved, that parties will be notified on when judgment will be given. Already some great degree of damage is done from the fact that this matter is not concluded before now, but that's not the fault of the party. I mean, that's not the fault of the court. That's the fault of the contesting parties that contestations have dragged on. But I'm still hopeful that between today and tomorrow, which are days before the election, the court will be able to do something. Yeah. Because the court knows, as you said, that it doesn't want to cause irreparable damage.
What do you say to those who think that, well, looking through the judgment, that they don't see where the court was specific, saying that either direct or indirect primaries, that insofar as it was the party that they ruled against, that they're ruling as a party, as an entity. So whether you had direct or indirect, they were referring to the political party, as it were.
Yeah, that's why you have the appellate system. Those contestations, in my opinion, do not stand with the law. What we need to look at, which is what the Court of Appeal does, the Court of Appeal does not hear the matter afresh. It simply examines the facts on which the Federal High Court, it will examine the facts on which the Federal High Court took the decision it took and determine whether that decision is consistent with the course of justice for those facts that were before it. All you need to do is look at the law. And if the law says, I give you power to make regulations for indirect primaries, ask yourself whether you can use those powers to make regulation for direct primaries that the law has already provided for, and the law did not give you power to make directive or make regulations on that. So I think they need to look at the law to ask themselves whether the Court of Appeal, to determine what to expect from the Court of Appeal, because we can't say what the court will rule, but we can criticize the last judgment that was made. And if you look at the law, that judgment does not stand with the law.
Give us your legal opinion on this before we wrap up, because on the general notes, when people say that since the appeal usually don't hear cases afresh, what if in the event that maybe at the court of first instance they think that there was gross injustice done and requires them to listen to some matters afresh? Would it make any sense to review that principle of not listening to things afresh at the appeal stage?
Yes, it would, because what the court is doing is sitting on appeal. And sitting on appeal is looking at the records. That's why they talk about transmission of record. Looking at the records of the court and determining whether the lower court acted consistently with the law, and therefore whether the judgment of the lower court should stand. The outcome of an appeal is usually we uphold the judgment of the court or we set aside the judgment of the court. So it can be any other thing. The court will not go into a new hearing, call evidence, or bring witnesses or anything like that. No, the court will not do that at the appellate court level.
All right,
so
then.
My opinion is that the court will simply assess what the Federal High Court has done and ask itself whether it's consistent with the electoral law on which it was supposed to rely in doing the work it did.
All right, Richard Nwankwocha, Associate Professor of Law, University of Port Harcourt, and the Chairman of MBA
Rivers State University.
Rivers State University, I beg your pardon. Thank you very much indeed. Always a pleasure to have you on, Prof.
Thank you, Chamberlain.
All right, so that's it today on the program as well. We'll. What am I thinking? It's a weekend already. Tomorrow is a big day preceding the big weekend. Maybe I think the whole weekend is going to be a whole new experience, but it's allowed. Well, thank you all for watching. I'm Chamberlain Uso.
I'm Gimba Umar.
And I'm Ayo. Makini, have a wonderful day.
Well, have a swell Valentine's Day. I'm Maukwe Ogun Yusuf.